Hello everyone and welcome back to the video updates. It's Sade. Today's video is going to be really quick and to the point. We will talk about how judgment liens might be avoided whenever they've been filed a long time ago. Typically, a judgment is granted in favor of one of the parties in a lawsuit. So it could be the plaintiff, it could be the defendant, it could be a third party that joined the case. So it really doesn't matter. What we would call that particular party that received a favorable judgment is a judgment creditor. In this particular scenario, the judgment creditor would have a monetary judgment. So it's a judgment for a particular amount of money. And of course, a lot of times there'll be interest on top of the amounts that were granted, and the interest would accrue from the date of judgment up until today, or up until the date that the judgment is satisfied, paid, or settled. So when the judgment is granted, it's granted within the context of a lawsuit. And then in order for the judgment to show up in public records, specifically in the property records in that particular county or any other county, the judgment creditor or the judgment creditor's attorney would have to get what we call an abstract of judgment, which is a summary of the judgment that took place in the lawsuit. The abstract of judgment is a separate document that's issued by the court or the clerk of that court, and the contents of the abstract of judgment will be the summary of what took place, what decision was made by the court regarding that money judgment. The abstract of judgment is then the document that the judgment creditor or the judgment creditor's attorney would record in the property records for that particular county. They could also record it in any county within the state, actually, because it's a valid abstract, but there's a separate process typically when they're getting an abstract to be recorded in a different county. So once the abstract is recorded, it's recorded in the property record so that it can attach to any real estate that the other party has, the party that lost the case, the party that has the judgment against him or her. So the abstract of judgment would be in there. Let's say I was the party that had a judgment against me, then if I have property in that county, the abstract of judgment would attach itself to that property. That's just the way that the process is. Just to summarize, for purposes of this video, it's for educational purposes only, as always. And so you would understand it in the sense that if there's a judgment, it doesn't automatically attach to property unless the judgment creditor takes that additional step of getting an abstract and then filing it into the property records. So the question that we received, and we received the question different times, we received the question in different ways, people word it differently, but they're asking the same thing, is that, let's say the judgment was granted a long time ago, will it still have any effect today? So the answer is it depends, because everything always depends on each state's laws, and it also depends on the facts of each case, the particular situation that we're looking at. And so in general, the judgment will stay alive for as long as that state says that judgments would be valid. And the judgments are valid in Texas for 10 years. Whenever the judgment is valid, the abstract is also valid, obviously, because the abstract is a summary of that judgment. Whenever the judgment is no longer valid, then that means the abstract is no longer effective after that point as well. As long as the judgment itself is valid, remember that the abstract is a summary of that judgment, so the abstract will also continue to be valid for that same amount of time. So they're connected in that way because the abstract is the derivative of the judgment itself. And so in Texas, it's a period of 10 years, but it's not set in stone, because there's another period where the law says that if I've had that judgment against me for 10 years, it normally would expire after 10 years unless the judgment creditor does certain things. One of the things that would allow the judgment to continue to be effective after that 10-year period is by renewal of the judgment. So the judgment creditor or the judgment creditor's attorney can certainly renew the judgment. And people would ask us, well, how would we know if the judgment has been renewed or not after that 10-year period? Let's say that the judgment was granted in 2005 and we're now in 2021, and of course it's been more than 10 years, right? So the abstract of judgment might have been filed into the property records right after. Usually the lawyers will file it within a couple of months or within a year after the judgment has taken place. And remember, the abstract of judgment has the same effect as the judgment in the sense that it's derived from the judgment itself. So if the judgment has expired as of 2015, then normally that abstract would also not be effective anymore against me, even though it was effective at some point. So the question is, how do we know if it's truly expired? How do we know if it's truly expired in such a way that we can challenge it if the creditor wants to then collect on that judgment after the 10-year period? The first way you would know if it's truly expired is if it was never renewed. So how does the judgment get renewed here in the state of Texas anyway? The way that people could renew the judgment is in two ways typically. By filing a motion to renew the judgment in the original case. Remember, there was a lawsuit where the judge granted that judgment. So the lawyer for the judgment creditor will go back and file another motion to renew that judgment, and then it will be renewed, and then they will just refile a new abstract of judgment typically. The other way that the judgment could be renewed is by asking for writ of execution, which is essentially asking for a document, asking for permission of the court to try to enforce that judgment in certain ways. One of the ways that people would enforce a judgment is by seizing property. It's by trying to reach a bank account, so those are different ways of execution. And so once the attorney asks for a writ of execution from the court, it automatically triggers that judgment renewal. So it's automatically renewed, even though there was no formal motion for renewal. Now, the other way that a judgment could potentially still be alive and well is if after the 10-year period, there's a dormancy period by law. So in Texas, the judgment would expire in 10 years, but within 2 years after that 10-year mark, the judgment creditor is allowed to come back and catch their mistake and actually ask for the judgment to be renewed. So it's still effective up until 12 years, if we're thinking about it in a technical sense. So 12 years for the judgment to continue to be effective against that other party. But of course, after the 10-year period, if you are the person that has the judgment against you, you're allowed to challenge it. And you will challenge it saying that that judgment is no longer effective, and a notice will probably be sent to that judgment creditor. And if the judgment creditor doesn't do anything, then you're probably going to win that argument against whoever it is that's holding your assets that's about to pay that judgment. So you would challenge it regardless that it's expired. And then if the creditor comes back and runs to court and gets a renewal, then of course you might have to settle with them, because usually you no longer are within the period or the window of time when you can actually appeal that judgment. So this is the quick video for you, and I think the takeaway would be, if you see that there's a judgment in the system, the first thing is to find out what is the period of time after which judgments expire in that particular state that issued that judgment. You would also need to know what is the period of time that's the period where the dormancy period, where the judgment is still in that window where the other party might have a chance to renew it even though it already is expired. And last but not least, you need to find out if there was a writ of execution that was filed in the underlying case. If there is no apparent proof of renewal, you can get an attorney to look into the underlying case to see if there was a writ that was executed or a writ that was requested, and that means that that judgment is not expired. So those are the things that I wanted to cover in this video. You still would need to consult an attorney, in my opinion, because it's not something that you could sort out really quickly by yourself all the time. You might have to get somebody to pull the file from the old case or to review the facts of the case in more detail to make sure that there might be a way to challenge that judgment. So this is the video for today. It's for educational purposes. As always, I hope it's been helpful to you. It's going to be helpful to people that have had judgments against them, or they have a friend or family member that's worried about an old judgment. And it could also be useful to the asset locators that are looking to help people to claim excess proceeds because they come across some liens when they're doing their research, and that scares them off. But you don't have to be scared, because everything is typically negotiable, or there's always a way to address something, or take care of it, or settle it, get rid of it. Lawyers know how to do that. So that's why it's nice for you to have a lawyer that you have a good relationship with, and that lawyer should be able to help you figure it out, and at least give you some guidance on that, and also give the person that has a judgment against them some measure of peace or hope, or some measure of knowing what their rights and obligations are in that particular case. And so that's what I wanted to cover today. And as far as the judgment itself showing up on the credit report, it shows up for the length of time that the state would allow, which is usually the 10 years in Texas. And when it's not renewed formally through the process of re-recording it in the public records or property records, then a lot of the times it will fall off of the credit report after the 10-year mark. If it doesn't fall off, then the judgment debtor, the person that has the judgment against him or her, he can challenge the credit report with the credit reporting agencies, and they would likely remove it. So sometimes it could still drop off of your credit report, even though it's not truly expired in the eyes of the law. And the reason that that would happen is if the renewal was done by writ of execution, or if the renewal was done just because there was a dormancy period, such as here in Texas, that 2-year time frame after the original 10 years, then it's actually still an active judgment, even though the credit report would have it showing as already removed. So if your issue is more about your credit report, then you might be able to still get some financing or credit offered to you if the judgment is not on your credit report. But if the issue is more of the judgment creditor being able to reach your assets, like your real estate, proceeds of sale, and things like that, then you need to do more analysis. You need to get a lawyer that does collection defense to try to challenge that judgment as being expired. And then if that's not a feasible argument, then the lawyer can figure out another way to address it. So hopefully this video has been helpful to you. As always, if you do like the channel, remember to subscribe so that you can also continue to get notifications if you hit that bell that's on the page. And if you like this particular video, remember to give us a thumbs up. Thank you so much for watching, and I'll talk to you next time.